examination and evaluation that the condemned prisoner no longer has the higher mental functions to appreciate the rationale and reasons behind the sentence of death awarded to him. To determine whether a condemned prisoner suffers from such a mental illness, the federal government and the provincial government shall constitute and notify medical boards comprising qualified psychiatrists and psychologists for public sector hospitals. This is a direction, and building new institutions for this. Then the other important thing, as I mentioned earlier also, but they also dispensed with the word civil surgeon and medical officer to be replaced by medical board. It becomes more institutional in its character to deal with these issues. It comprises of experienced psychologists and psychiatrists. That's the direction given to the government. So we know that the decision finally that came out was that the death penalty was converted into life imprisonment for all. And for one, the mercy petition is pending. I don't know what's the status. Maybe Sarah Bilal could tell us later. But the mercy petition was pending before the president, and a direction kind of was given that the president would look at the mercy petition in the light of this judgment. So the judgment also goes beyond the trial and goes into the clemency process, which is before the president. So I think it goes into that area also, which is outside our legal thing. Number of other directions were given which are very useful, and I'll just move on to the future. Is that the federal government, all provincial governments shall immediately make necessary amendments in the relevant law. So we are waiting for those amendments to come, and I think the activists and the people who are looking into this area will make sure that these amendments do take place. Similarly, amendments in the prison rules. They also talked about setting up new high security forensic mental health facilities which need to be established. Medical boards need to be established. A lot more awareness has to be done, and so the judicial academies have been asked to start training programs. Our judges need to understand, our lawyers need to understand. We don't have a law program in any law college that probably deals with mental health. I mean, I've been teaching for a number of years, haven't really come across mental illness or mental health issues or mental health law for that matter. So I think it might be high time for Justice Project to maybe initiate a course at law colleges, or for the members of the bar to look at the mental health issues. This is an important area. What could be more dearer to human rights than mental illness and mental health? And I think for young lawyers sitting here who want to practice further, we need to look into this area and could become experts in future in this area. Thank you for giving that little break. Okay, so let me just, having said all that, let me just one paragraph summing up the whole thing, and then I move on to the, what my ideas are for the future. So this judgment that reinforces the rights of mentally ill defendants in the criminal justice system, not only has the court established key safeguards for mentally ill defendants on death row, it has reiterated and upheld protections that must be afforded to persons with psychosocial disabilities at every stage in the criminal justice system, at the time of arrest, during investigation, trial, sentencing, in order to ensure that they are to guarantee due process. Also look at the clemency process which is under the president. It has also barred the execution of individuals who are severely mentally ill. So this is summarizing the judgment. So now let's revisit it, and if I were to sit on it again, and the case comes up again after this period that is 1 year that has passed by, and I would add a few things to it. And these are some of my humble sort of suggestions. These are purely mine, of course. I would look at it on a fundamental rights framework. I think the fundamental rights were not really talked about. Maybe we all missed that out, but I think that needs to come in. I would look at right to life, and I would look at right to dignity more than anything else. I would anchor the whole judgment on the right to dignity, which is so dear to me as a concept, and I think that's the only one of the strongest fundamental rights which is not subject to law, by the way. It's not subject to any law. You can never take away dignity from anybody. You could take away life, subject to law, but never dignity. Article 14, if you reread it again, you'll see that. So I would reconsider such a judgment in the light of the framework of the fundamental rights. I would not be too pushed if the prison rules are missing. I would not be pushed if CRPC isn't really talking about it. I have right to dignity, which I could turn the whole thing around on right to dignity, right to life, and right to fair trial. I think that is absolutely, there's so much power in these articles that I mean, all the laws flows from the Constitution anyway. So I would base it on this. So, and I want to talk about dignity a little because that's very close to my heart also, and I think it's a very important area. So human dignity encapsulates the notion, we're coming up with a lot of jurisprudence on dignity, you know, so stay tuned, as they say. Human dignity encapsulates the notion that every person has inherent equal worth. This simple but profound concept has three elements. First, every member of the human family has value. This is important. No one can be dismissed, ignored, mistreated, or abused as if their humanity means nothing. Second, each person's worth is equal to every other person. No one's life is more important than any other person's. Third, human dignity inheres in the human person and cannot be taken away. So if you have to clap, this is the time. And so I've already mentioned that you talk about the right to life, which is also very dear, and fair trial, talking about this process. I would also put a lot more burden on the prosecution. I would say that they have to establish the case, and if on the record it has come that the person suffers from mental illness, prosecution better clear that point, you see. So I might fail as an accused, but prosecution must establish that, no, sir, there is no iota that this person is absolutely normal. There's nothing wrong with him. I think prosecution needs to do that. And I think the courts now need to move after reading this, and I'm sure the courts will. I don't know if there's a term, but more pro-mental illness kind of inclination or propensity, have a more proactive approach towards mental illness. That's important. We should be now more talking about science. We brought science into the two-finger test judgment that has come out. We're bringing science into DNA being the gold star standard or whatever. So we want to bring in more science, and I think the courts need to bring in more science. But another thing that we need to introduce in, Mr. High Commissioner, this is actually quite an Australian concept also, the therapeutic jurisprudence. We need to move on to therapeutic jurisprudence. Now this is for the well-being of the offender. The court must be so sensitive by looking at the whole thing that I must have a therapeutic effect on this issue. You can't sort of bring it in a company law matter or a taxation matter, but do bring it on when they're talking about human rights. So I think we need to introduce therapeutic jurisprudence in Pakistan. And we need to think about the well-being of that human being who's before us, and let's not be lost in what the prosecution is saying or what the accused could prove, but we could take up an inquisitorial role in such matters. So it need not be adversarial, to my mind. We could consider a slightly more inquisitorial approach in looking at this aspect. And, you know, if it is established that Imdad or Kaniz or Ghulam Abbas were mentally ill at the time when the commission of the offense took place, I would rather acquit them. You see, there's no offense that they've committed. They ought to have been acquitted. Why life? I mean, by convicting them, you're still punishing them, are you not? So that really bothered me throughout the case, but you know, you have a 5-member bench, you have to go along at the end, and you wanted to come up with a judgment, but that did bother me. If we can establish that at the very beginning he was suffering from mental illness, then you can't give him any punishment, no conviction at all. So I would rather acquit the person if there was such a situation. So I think in a case that might come in future, we might consider this aspect that acquittal would be the solution, and they ought to be sent to a facility or whatever, but we need to look at it with a human face. Where do they go? You see, we just decide things, but where does the person go? He's a human being, or she's a human being. So rehab, facilities, we need to have that kind of aspect to the judgment also. We can't just say, turned into from death to life, and then what? Where does the person go? He's suffering from mental illness. Should he not be, or she be sent to a mental facility? Or what are the steps regarding rehab? The Supreme Court could say, okay, give us a monthly report on what you're doing with this person. That is therapeutic jurisprudence. And I think Safiya Bano sort of pushes us in that direction. We need to go in that direction. I finish with a quote. The strongest people are those who win battles we know nothing about. Thank you. Thank you very much.